And all present, respected dignitary, faculty members, and my student friends. At the very onset, I, Sibani Patnaik, a student of 6th semester BLLB Honours on behalf of Royal School of Law and Administration, would like to extend a warm welcome to the invited resource person, Sir Subhajit Banik, Advocate Gauhati High Court, to deliver a lecture on the topic Ethics of Legal Profession in India. Sir Subhajit Banik has completed his formal education from Don Bosco High School, Gauhati. He has been a meritorious student throughout his educational career. He has completed his BSc Honours from B. Borua College, Gauhati, and LLB from BRM Government Law College, Gauhati. As a lawyer, Sir has mostly practiced in Gauhati High Court in the fields relating to civil, criminal, arbitration, and other matters. Sir has also appeared substantially in Meghalaya High Court and at National Green Tribunal, Kolkata, and occasionally has made appearances at the Apex Court. Now, I would like to invite Dr. Pranita Chaudhary, Associate Professor, Royal School of Law and Administration, to felicitate Sir. Before we get started, we are very pleased to be able to Subhajit Banik again for delivering an effective and educative lecture on the topic Ethics of Legal Profession in India.
If you really want me to talk, then let me start in a formal way at least. I'm thankful and grateful, privileged and humbled to be part of this august institution, to be able to be associated with you guys so that in our pursuit and endeavor, we reach somewhere which will help us in the days to come. Having said so, cut to. Now, the topic given to me is ethics of legal profession in India. Before that, I must tell you one thing. Bhuban Barua sir was my teacher long way back when I was a student of law. Even I am now, but I'm practicing. And the two amidst here who had done the internship with me, may I see their faces? Stand up. Good. Sit down. They know me a little more better than what you guys do. I like the way the introduction was said, read out, delivered. The diction, the speech, the content, the research was good enough. But the only thing is that I do not deserve all those things to be said. And at least I expected a round of applause after that. But that didn't follow. Anyways. Some good things were said about me, no claps. So what's the point? That's what I said, there's no point in being formal. Chalo. Before we talk about legal ethics, we must all, am I audible again? Because I'm used to, stand and talk. I'm not used to sit and talk, right? Anyways, before we talk about legal ethics, professionalism, professions and all, it's absolutely important for us to know how we Indians started the journey of law, reached a point where we were called lawyers, accepted in the society, and now we talk about ethics. Let me tell you a journey of 200 years in a nutshell, without being very sketchy, but relevant. See, 1726 to 1926, 200 years, the things changed. Initially, what happened, we talk about a story. Prior to 1726, the courts and all were directly under the control of the East India Company, right? Now there came charters, which we call firmans and all. Once these things started to come, slowly and steadily, we started to progress. The point is how we identified ourselves. The Charter of 1726 did a wonderful thing. It established royal courts in Bombay, Madras, Calcutta. Now these royal courts were the courts of where civil cases would be heard, albeit with the help of the English law. Think up light. Our civil cases were being decided and heard on the lines of the English law. And the criminal jurisdiction was vested on the governor. So this is the thing that we had no choice, but our civil cases were to be decided by English laws, and that too under the charter. At Calcutta, was established. We are very happy. Now we could practice in the Supreme Court. Sorry? The only permission was given to advocates and attorneys. By advocates, I mean British and Irish advocates. It wasn't given to us anymore. So we could not even practice in our own Supreme Court. We move forward. At that point of time, the Bengal Regulation Act came. Sometime, I forgot, in 93, 1793 or all in all. Now this was a policy of divide and rule also, if you look very thinly, because this allowed only Hindus and Muslims to be pleaders in the company courts. And the rest were not allowed. Move forward. 1861, the High Courts Act came. Now the High Courts were established. And the Advocates Act is 100 years down, 1961. Mind you, we are nowhere. Now this time in the society gave birth to a thinking that whether there should be some consensus that on a national basis there could be a body, a union, something, a bar, which we call National Bar. So a committee was there in 1923 which discarded this theory, this proposition that there should be a national bar. Anyways, but 1926, the act came and the bar was formed. 15 members, 4 to be nominated and the 10 to be elected from the members. So far so good. This act, when we moved into the post-independence era, what had happened is that now came the part of a thinking that there should be bar councils. Initially, there was no concept of an All India Bar Council. There was only state bar councils. So Advocates Act 1961 brought in the concept of an All India Bar Council as also a state bar council. Now once I am to talk that here when we reach the Advocates Act, at this point of time we recognize that advocates meant only two things: the advocates and the senior advocates, and of course advocate on record in the Supreme Court. Earlier what we said, the Indian advocates would mean vakil or pleaders or mukhtars. If you're familiar with the terms, vakil was under different act. They had to some qualifications. They could be act as agents of the clients. They had no status otherwise. It's gone. Those days are gone. Pleaders, they had to pass a pleadership examination under the courts, and they would be given a certificate to practice in a subordinate courts, albeit in a very diminished way. And mukhtars were also, mukhtarship courses were there, and they were given into the criminal side. But these things are gone now. The Advocates Act has come, and the advocates we are practicing now. Starting from or stemming from the Advocates Act, we have the concept of the Bar Council of India and the state bar councils. I'll come to that later. But Madam had told me that I was to talk on certain issues, but these are not familiar to me. I'm an arguing counsel, isn't it? The first one was, if I recall, some clinic, education clinic. Could I have that word, please? So we have reached the Bar Council of India, how the journey it had and how it was formed. Anyways, something to do with a legal clinic. What happens is this: you all are students of law. You will learn law, you'll understand law, you'll unlearn law, you'll be confused with law, you'll be experts at law. But then, it's all in the realm of theory. It's all in the realm of theory. This would be of no help until and unless you are exposed to a practical field. That means, unless you have an idea of the environment you're going to be put in after you pass out, if you want to be a practicing lawyer, then all this knowledge would be of no help. Considering these things, there was the birth of the concept of clinics. The journey started way back. Sometime in 1949 in Bombay, there was a thought that there should be practical training. Look, we had no existence earlier, and now we are talking of practical training of lawyers. So 1939, the Bombay the group, they mooted the idea that there should be practical training, but they restricted it only to those who take up profession of being a lawyer. They did not do it otherwise. The law reports, the law commissions also supported that no, this should be confined to those who would be a lawyer. Otherwise, what's the point? Giving them practical training. But there was a winds of change. It started sometime in 1993 with a Chief Justice conference saying that, with a Chief Justice conference saying that there should be a committee. The committee should see that the law grads who eventually come to practice, they're at least trained to do that. This gave the shape to 1997 when the course was changed. The BCI told the universities and the law schools, look here, we are going to make 21 papers compulsory, 2 optional, and 4 practical training. You may add a few more, but this structure has to be maintained. From there, 2002, the report came when this practical things or the clinics were made a part of the curriculum. So when we talk about the clinics, what do we understand? That in substance, it's an idea of the practical world. You guys would be put in a threesome position. The first, a simulation type. The second, an in-house type. And the third, out-house type. What is it? Well, briefly put, suppose you are exposed to a courtroom scenario. Howsoever, it may be simple, elementary, rudimentary, but let's say a courtroom scenario where you have to either be a judge or be a lawyer or be a witness or whatever you do. You spoke well. Now, we call them moot courts. In moot courts, you have no idea what you're doing, but suddenly, of whatever ideas you have about a court, you take sides, you do research, and you actually plead. You place your case, your arguments, but you have no idea. This is called, in an environment where you got a feel of what's going to happen. Next is the in-house. What happens in an in-house environment is, a section of the people of the society, they're called. Now they have a common pattern of problems. They are called and they are told, usually they are poor people, and they are told, look here, we have a team, our students are there, they will interact with you, they'll listen to what you have to say, your worries, and they'll give you suggestions, they'll give you advice, legal advice, come. And these people would come to your institution. This is in-house, all right? And you'd be given to interact with them, of course, under the supervision of your teachers. Now what happens is, all of them have a similar problem or similar kinds of problem, and they talk with you seeking similar types of solutions. So all these things, although it helps you to understand client in a direct fashion, yet the diversity of it is not there. That's absent. The outhouse is where you're taken out to some legal aid camp, etc., where you'll be put there and made to talk with a vast section of people. Each one will have a different sort of problem, and then you would assess and give your opinions. This is so far as this clinic system is concerned, because it's been put in by the 2002 report that it has to be part of the curriculum. I don't know whether it's good or bad, because these are half-baked knowledge. Half-baked knowledge is dangerous. What happens is, when you go to a professional, someone who is practicing law, who has the expertise to deal with it, he would give you a proper solution. Arguable, debatable though, but that would be a well-calculated, reasoned solution. When the students are exposed to that level, once the outhouse is over or the in-house is over and the people go back, they tend to believe that this is what their rights are, this is what the solutions are, and this is what should happen. End result is that somewhere the society suffers. Neither the student has learned nor the society has gained in the name of clinics. It's neither good nor bad, but a part of the curriculum you must go through, and therefore I say, put in your heart and soul when you talk with people. because they believe you, they trust you. Just like when you go to an hospital, the lady or the guy might be the first day he has joined in, but you expect him to do it in an emergency. You have no clue whether he has understood the problem or not. Similarly, try to put in effort there. This would take us to the second point. Second point to kya sila? Sorry. Anyways, I'll go on. How to handle with clients. The ethics part is all the way. The first point of ethics is when there will be clinics. When there will be clinics, yeah. Then you have to maintain the ethics to yourself. You have to be honest to yourself that you have put in that effort, done that research, done that homework, studied the part, talked with the persons in the correct fashion. If you don't do that, it's not done. You have lost on the ethics on the day one. This is also a concept of ethics. It's not what you read in the books alone. To be honest to yourself, to be honest to the person you talk with, to be honest to the environment, to the subject, is also a part of the ethics, which must be taught. Either it's there in your blood or not, I don't know that. But once you're in the world, you have some responsibilities, some duties, and these things must go hand in hand. Secondly, when we talk with clients, technical terms may be interviewing, lawyering, etc., etc. But kindly think, a person who has a problem has come to you to tell you the problem and yet is not being able to open up. It's not so easy to tell a problem. It's easy to listen to a problem. I tell you, even if you have personal problems, try and go to share it with some friend or others. It's difficult. And here the person is a stranger. It's very difficult. So what is your role? The role is, let the person open up. The opening up can be of two fashions. First, there is a part of lawyering, though. You have to make the person comfortable. Now, how do you make the person comfortable? Look into the eyes. Softly. Talk. Share experiences. Do not come directly to the topic. Talk to the person, not about the problem, but talk to the person. Share things. Eventually, the person starts to open up. Now, this can be done by a research method of questioning. The questioning goes from vast to narrow. How we do it? Suppose, I'll give you a common example. Suppose you have a client, and that client is accused or alleged to be involved in a murder and was seen by a doctor's clinic on the particular date or day and time when allegedly someone was killed. And you were interviewing that person. He or she is very scared because knows either is innocent or guilty, but you start to talk to that person. This is called interviewing and lawyering. I start with a theory of open-ended to closed questions. How was your day? Good, bad. There can be two answers. Good, bad. How was your day? Good. All right. All well in the family? Broad questions. Yes, no. Or maybe they don't answer. If they don't answer, then kindly pause and say, take your time. We can talk. Eventually we can talk about the problem, but take your time. They open up now. So you had a sore throat, didn't you? I narrow down. How was the doctor? Is he good at that? I have a problem too. I am narrowing down. Yes, good, okay, nice, that would be. So you had your tests done. Were you there? What was the name of it? Say we put it X diagnostics. Is the facility good? Do we have to put in a much longer waiting time there, or they give the results fast? It's good. They have a soft copy version of that. They have no clue. Yes. When did you go last? Comes to the point. We narrow down the information we need. When did you go last? There's a pinpointed question now, and the person has no idea that I'm eliciting information which I need. Now there may be instances where it might be delicate. Abuse. There might be instances of abuse. I tell you, abuse is far stronger than violence. It's far stronger and deeper than violence. Abuse has a mental impact. At times, the person would would show tantrums, would show different types of behavior if he or she is subjected to abuse. Handling these sorts of issues, they require a different level of maturity. It's not only the fees, it's not only your job, it's your duty to be concerned with about the person, the state of mind, and what the person is going through. That's all about lawyering and interviewing. But there's one thing more. Maintain your dignity, your self-respect. You didn't walk down here just like that. You studied so far. You worked hard in life. And therefore you are there in the position that someone has come to you to seek advice. That doesn't make you at a higher level. At least at a respectable level. Now once you start talking, if you talk nonsense, if you talk loose, or if you talk fast and loose, everything goes away. It goes out of the window along with your respect. So therefore, understand what to talk, when to talk, and how much to talk, because the situation is tricky. The person is aggrieved. Number one. Now talking about accountancy. Yes. There's something called accountancy. It may mean two ways of it. Your books would have one way of interpreting it, I would have another way of interpreting it. Number one, being accountable or in accountancy with the financial part are two different things in the same vocab, if I put it that way. See, you need to have a work done. There's a time limit. That accountancy also takes into the context the time management factor of yours, how you have done the thing within the time period given to you. You cannot delay it, you cannot procrastinate, number one. And the other part of it is, if you want to charge fees, how to do that?